Hi, this is Joe Gailey. I want to welcome you to another one of our educational webinars on the issue of employees and your business. What obligation does your business have to employees, and what kind of legal damages might your business have to employees? Today, we're going to talk about the Federal Labor Standards Act, the FLSA. Now, that is the initial labor law. I guess it started them all. It provides for a 40-hour work week, and you have to pay overtime in excess of 40 hours. Now, the whole question, or one of the major issues about the FLSA, is whether employees are exempt, that is, they're exempt from overtime, or whether they're non-exempt. That is, whether they're traditional hourly employees that have to be paid overtime. Now, many times there's a great myth out in the public that if you pay somebody a salary, you don't have to pay them overtime, and that is simply not true. Whether they're paid a salary or whether they're paid hourly doesn't really make any difference as to whether they are exempt or non-exempt. It's their duties and how much they make. There are two major exemptions that most small businesses find is available for them to use. One is the administrative exemption, the other is the executive or managerial exemption. Both of these require that the employee be paid at least $684 per week. If they are paid less than that amount, they will never be exempt, regardless of what their duties are. But if they're paid more, they may be exempt depending on their duties. On the administrative exemption, that requires that someone have a specialized knowledge, perhaps specialized education, and that they make more than $684 a week. Now, examples of that would be nurses. Nurses certainly would be exempt from overtime if they have the educational requirements of specialized knowledge. If they make $684 a week at minimum, then they could be exempt. Administrative employees, accountants that use discretion in things, they could be exempt. So those are the types of people and the types of classes that get exempts. But by far the largest class of exempt employees is what's known as a managerial class, or the executive class. Now, the test to be an executive or managerial exempt employee is this. You have to make more than $684 a week. Your duties have to be primarily managerial in nature, and primarily means of the highest importance to the employer, or at least that's the way most courts interpret it. However, some courts interpret it as primarily being a test of time. So if you have a manager that spends more than 50% of that time doing the exact same things that other rank and file employees do, you may find that they're not a manager at all. They're not an exempt employee. Thirdly, the management or the manager has to be able to hire and fire employees, or at least have a significant influence over the hiring and firing of employees. Now, this gets into a real contest sometimes when employees, let's say that you have co-managers in a store, and on their own, they decide one likes to do inventory and reorder product, and the other likes to hire employees. So instead of having both of them participate in the interview, they just decide, you do the interviewing and the hiring, and I'll do the other. And as a result, the one employee that does not participate in the hiring process may not be exempt and may be entitled to overtime. And this can be a costly mistake for an employer. Now, if you are a non-exempt employee, then you still have to be paid for minor or de minimis breaks. For instance, if an employee takes 10-minute bathroom break, they have to be paid for that. On the other hand, if they take a 1-hour lunch break, they don't have to be paid for that. Many employers get tripped up on when they have to be paid and when they don't. The Department of Labor has a bright line rule that any absence of under 30 minutes has to be paid, and any absence of 30 minutes or longer doesn't have to be paid. So smoking breaks, bathroom breaks, and in some cases even lunch breaks, if they are under 30 minutes in duration, have to be compensable. And if the employer makes those employees clock out and clock back in, they're actually violating the FLSA. And this can lead to a lawsuit and some costly damages. In our next installment, we're going to talk about the damages that an employer can have for FLSA violations. Thank you for tuning in, and we welcome you to tune into our next installment on this very important issue for your business.